I would rather not use the microphone. I feel like I'm ever. Or the communication. Can y'all hear me well? Okay, well, good morning again, as I said, I hope you all have been enjoying this wonderful place. This is my first time being in Cherokee. I was super excited to be here, and it's been beautiful and peaceful. So I hope you all have had the same experience I had, the same experience with summer. So we will officially commence our July 2025, July 2025 meeting for this year. And we will start with, well, first I'll read the Ethics Act statement. Members of the committee are hereby advised of their duties under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict. So if you have one now, please note that, but we realize later that have a please note it at that time. And we will start with the agenda item, beginning with report on first account audits.
You have the report on first account audit, in your materials, to the addendum. We do have a new field auditor, and we provided his first report this quarter. You see, one of the things to continue to note, I think I'll just stop saying it after a while, is that the adjustment we made to how random audits are selected has worked. You see that the most, audits occur in Wake County and Mecklenburg County, where most lawyers are. We also see that the most common rule violations were not having corrected provided to the bank reported for misappropriation, which is different than your quarters past. Most of the other quarters usually find that folks are not doing reconciliations, they're not keeping up with all their other records. The fact that this was the top rule violation, that lawyers have not provided the bank with the corrective to say, if I misappropriate or or so if my balance goes negative, you need to report that to the bar. I was surprised that that was the top one. I was surprised that there were 38% of those audited that didn't have that correct. But nevertheless, we'll continue to work on that educational piece. So that's the report.
Thank you, Ron. Next, do we have any questions or comments? Next, we'll move to report on ethics phone calls during the prior court.
Can y'all hear me? We had 1,079 inquiries that we answered. That's actually above average for this particular quarter. The top three categories were the same as last quarter, but different order: conflict, advertising, and confidentiality. Last quarter was conflict, always first, confidentiality, and advertising. That's it. Stay busy in the summer. You can't hear me? Okay, can you hear me now? 1,079 ethics inquiries last quarter. It's above average for the summer quarter. The top three categories of inquiries that we got were conflicts, advertising, and confidentiality. That's the same as it was last quarter, except it was conflicts, confidentiality, and advertising. But those three stayed pretty consistently up in the top. And that's it.
Thank you, Suzanne. Any questions or comments? All right. We'll move to report on COE ethics presentations going to five.
And as always, we try to make ourselves available for any sort of CLE requests. You see, the staff conducted 10 different CLE presentations over the past quarter. We continue to get a lot of inquiries for artificial intelligence CLE presentations, but we had a couple of other just random ones that came up over the past quarter, ranging from the State Farm's ethics process, which is kind of a staple, to some specifics about conflict of interest for public defenders, and there was even one in May that was a family law CLE in the theme of Taylor Swift. So if anybody has a Taylor Swift themed CLE program coming up and you need an ethics talk, we've got one in the back. Just throwing that out. There's the family law section in Charleston that wanted to be Taylor Swift theme, so it's all there. But that's it. We try to make ourselves available, of course, if you have any sort of opportunity for us to come out there. you have a need for a particular topic, please let us know. We will do whatever we can to make it happen.
Any questions for Ron? All right. Next, we'll move to our subcommittee reports. We have Kemp, Public Defender Offices in multi-county districts. And Nicole will call on you for overtime.
So this is one we've been talking about for quite a while, but we're gonna continue to talk about it for quite a while. This inquiry started out as a formal ethics opinion to address public defenders' offices and dealing with conflicts of interest, particularly in the smaller communities, communities where there aren't enough private lawyers to refer conflict cases out of the public defender's office. So I prepared a formal ethics opinion, and the committee talked about it for 2 quarters and then said, we don't like this. Let's do a rule. The opinion talked about screening lawyers within the office. Some public defender's offices are in multiple counties, and each county will have its own public defender's office, although they are headed by the chief public defender. And so the opinion went through an analysis of how you can screen and provide written notice. The subcommittee decided that a rule amendment would be better, so we started looking at Rule 1.10, which is the rule on the imputation of conflicts. It basically says that one lawyer in the firm has a conflict, all the lawyers in the firm have a conflict. The proposed rule will create an exception for lawyers in the public defender's office and lawyers with the Department of Justice to allow them to take on conflict cases if they can screen and provide written notice to the affected clients. So the subcommittee is right now discussing that. There have raised some concerns about screening and what we called the ick factor. One of our visitors talked about the ick factor, and if it didn't feel right, then the case should be referred out, and that's going to be based on what kind of confidential information does the office have regarding either a witness, a co-defendant, or a witness, something like that. The committee wants to discuss that further. They also have concerns about providing written notice and whether or not that really is feasible, because defendants tend to be mobile and they don't have a permanent address, or they don't know where their permanent address is, and whether or not they could provide prompt written notice of the screen. So the subcommittee wants to continue to discuss that and flesh out the right wording and language. There's also going to be a proposed additional comment to address these issues as well.
All right, so Nicole spoke about the it factor phrase that we use, and I think with Rita Baker Harold.
Yes.
On the tab, actually, her full phrase is if it feels icky, it probably is. I think if we were really looking for a clever way to put that in the rule, I'm not thinking we will be able to do that, but we all understood what you meant by that in the group. So I know we have our subcommittee members here. Do we have anyone that wish to speak on that, on this particular inquiry? Anybody? We all agree. We sent that, all right, we won't belabor that then. All right, do I have a motion to send this back to subcommittee?
Reluctantly, I make the motion to send this back to us.
Second.
All right, I have a motion and a proper second to return this to subcommittee. Any discussion? All those in favor, please say aye.
Aye.
The opposed, nay? All right. Next one, number 2 is real estate client referral, law partners business. Brian Staff, please.
All right, so this inquiry was really pretty simple, and then Judge Lange got his hands on it. Everybody's talking about it. This is the inquiry dealing with this question. I guess the primary question that came up from staff council based on a variety of calls that have come to us over the years. You know, when you have a closing attorney who needs to get title insurance for the client, the one option, of course, is to go to a title agency. That's the typical traditional thing. Well, the situation that was presented to us was, can a closing attorney go to the title agency owned by his law partner. Or whether it's, whether the closing attorney is an associate, fellow partner, whatever it is, but just this question of, can that closing attorney basically send business over to your partner's title agency? And whether or not that's a conflict, whether it's an imputed conflict that would really prohibit the closing attorney from reaching out, or is that just a, personal conflict such that currently, as our ethics meetings read, an attorney can't be both closing attorney and the title agent. And so this kind of a variance on that scenario that we do not have an opinion on. So we introduced this back in April, and we had our first two subcommittee meetings over this past week. And the first question was really just kind of I guess I put in the memo a question of whether or not that original understanding, that original decision was still appropriate. That being, a closing attorney, or should a closing attorney be prohibited from serving as both closing attorney and the title agent? And then, kind of based upon that answer, presuming that answer remains, no, we can't do that, as we've had historically here in North Carolina. Then, we move on to that question of, what if it's your law partner that you're procuring the title insurance from? North Carolina is different in this regard. There's a lot of reasons for those differences, but it's safe to say that we have struck a nerve in the real property community, because we've been getting a ton of different feedback, lots of different comments from folks. Folks had reached out to us, and I'll tell you what I told them, and I always tell folks, there's a time to comment on these inquiries, that's usually after publication, because otherwise you're commenting on something that you don't really know what position the ethics committee is taking around. That said, we've received a lot of feedback, as you saw. We wanted to include that in your materials, so you could take a look at it and read along with the mess that Judge Lang has made. But but we did see stuff from both sides. Some folks are saying, no, it needs to stay the same. Yes, North Carolina is different. By that, I mean, North Carolina is different than South Carolina and Virginia and a number of other states, and we can't get into all the details here, but this notion in other states, including there's an ABA from the 70s, that says a lawyer can serve in both of those roles, closing attorney and title agent, provided there's appropriate disclosures and notice and all that stuff. So why is North Carolina different? And we had to get into that discussion. We invited at this last subcommittee meeting, we invited members that had provided comments, individual lawyers that are either some that work with title agencies, some lawyers that are just a part of the Bar Association's Real Property section or any other associations associated with real property, as well as some of the individual lawyers that think the rule in North Carolina should change. We have statutory considerations too. That makes us a little different. Again, it's not, we don't have the time to get into all of the different nuances here in this committee meeting, but the last meeting I thought was very, I thought it was interesting hearing from the different sides. There are folks that just disagree with each other on interpreting statutes and rules and all this kind of stuff. So we are going to continue to wrestle with this. We do not have an opinion, and this was also one that I'd say I did not draft a proposed opinion because I didn't want it to be potentially weaponized one way or the other. And we are just not in a position yet to start drawing a conclusion, but that's where we are at. A lot of work this past quarter. I also have to say, I don't know if anybody's been contacted individually as a member of the ethics committee. What's that? Well, I know some people on the subcommittee, I don't know if anybody off of the subcommittee have received any sort of direct contact. If you do receive anything, please just forward it to me, because the chances are I've already received it, but I want to be sure that we are keeping track of all the commentary that comes in. Even though to anyone who's watching on the live stream right now, please don't comment until we have a proposed opinion. We're not at the point where we can receive comments, but that being said, it's sent to I want. So that's my report, Judge.
Great, I think we reached out to about availability for a meeting Yes, you can have a draft, but then before that meeting, so we have something.
I mean, I could try, but I don't know what that's gonna be.
I think there was much appetite based on questions, and comments from the subcommittee members for a change.
Yeah, and I feel like that's what we haven't really gotten into the imputation question just yet. I think we've been focusing on that first question initially, but yeah, I agree with your assessment.
So it sounds like the thing might not be proper or prudent to formulate a proposed opinion at this time.
Well, I mean, I think there's these different steps. The imputation question, we have not even really begun to discuss. And that may be something where, we could have something, like you said, it's nice to have a draft to let us start to work off of. So depending upon when the next committee meeting, gets scheduled, then, if it's like 2 weeks from today, then I'm not probably having it. But we will probably have something. We could have something if we want to start, absolutely.
Any other comments? Any other subject there?
I read all this, and especially those that were opposed to me change. And, things will come before this committee that we have to change or drill down on because the world has changed. This is so, as it was when I started practicing law before many of you were born. I read this law, it's in this rule, that's 900. So I don't understand how anybody in the public is hurt if we don't permit this. Who's hurt? And that's what our main charge is. So we're, and further, if we look down the road, better than I'm able to, but you don't votes, and I'm sure there might be another instance where some other little thing, this little thing that you have in your fall from comes important, and I can hear them saying, oh, back in the day, we, and then in time. So I'm ready to propose that we may quit looking at that. The answer, which we did, and then I heard about this. So my 2 cents from being out there.
We appreciate it. Yes.
Is your sense from the conversations that you've had in the subcommittee meetings that lawyers are doing this and that's why they want the change, or they became aware that this issue was before you because of the implication issue and therefore saw it as an opportunity to say, hey, and by the way, change this whole opinion?
No, I think it might be a little bit of both.
I mean, that was sort of my sense from a couple of the comments, but I didn't want to make assumptions.
Yeah, I feel like it may be a little bit of both, and I think that's where my sense, I don't know all the different business structures that are out there, but I understand that there are different efforts to kind of distinguish, I'm not the title agent, I may own the agency, but I'm not the title agent per se, so I can close and get insurance. And that's the sort of thing that I think this first question, I have to say, that I wonder if I opened up the can of worms, because it's a question that we have answered previously, but I think the last time we wrote an opinion on it that really directly addressed it was probably over 20 years ago. And so, in my view, a lot of the times when we've run into these issues, and it's kind of there's an opportunity to say, hey, this was the decision then. It still remains relevant and appropriate today, and it strengthens that position. It's similar to, I would liken it almost to the AI opinion, where we are dealing with something brand new, a new scenario, a new question, a new sort of set of facts, but the principles remain the same. And so we can apply those principles. So the main focus of the inquiry is really this question of whether or not a lawyer can send business to his or her partner's title agency. And that's the one that I think has produced more of the question in staff's mind in terms of the response to the questions that we've received, the guidance that we've tried to offer, different opinions. Not necessarily on changing the first question. The first question I'm hearing, I think the judge was correct, I heard from the subcommittee, kind of, what you were talking about, Nancy, kind of is the public is not harmed by keeping this in place. It is the way that business has been done. Changing it would be pretty significant, not to mention, there are statutory restrictions. We had the commissioner of insurance reach out to us just to say, we're not involved with this, we're just aware that you're talking about this, want to make sure that the subcommittee is fully considering this in the statute. Which I think would be pretty strong message. So that, but yeah, we do need to get into the implication question.
As Brian said, we've got work to do, but Nancy, we were fearful that a change could actually be harmful for the public, especially in the residential context where you could have a client whose only contact with the legal profession is in connection with a closing for their residence. And there are ways you can word a title commitment and title policy that would not be very beneficial for that consumer, but could allow somebody to pocket a premium in a way that causes them not to have to take much risk. I know it's nuanced, it's probably not something that we can really talk about right now because it's pretty involved, but we're worried that if you pivot the other way, it cause harm.
Yeah. One thing we're blessed, I believe, behind this wonderful public. Pick one out, you don't have to go to the different title company. Even if you have a problem, I've had problems with my personal residential real estate, and I was forever title. The title company that was willing to insure over. And this is, they all, you know, I read what, 3 or 4 letters from title companies saying, please don't do this, you know. So I think that that's a subtle, one of those considerations we're talking about, that's not the statutes, but it's the true fact of like.
Yes, sir.
From a theoretical standpoint, Brian, is the underpinning for South Carolina, let's say, or Virginia's approach, that this is not an imputable conflict and that it is just this, it can be waived with full explanation and consent from the party, from the client.
Well, and I think that's kind of this is the sticky part of that question, because yeah, the imputed, just going beyond that first question, which I think we're all saying it's already been decided. It doesn't seem like there's an appetite to change that. The imputed nature of this, if we're talking about a partner that owns a title company, they can't serve as closing attorney in that particular transaction because they've got a financial interest. But that a personal interest. And of course, personal interest conflicts do not get imputed to the other members of the group. Or is it some other conflict, a conflict, that you have, not necessarily based on a personal interest, but based upon your responsibilities to this third party, maybe it's more like a fiduciary sort of thing. And is that something that could get imputed to the other members of the firm? And even if, I think that's the thing where then you get to the question of waiver. Could it be something that a client could waive? And we kind of run up against this notion of, again, it's as much the application of the rules as well as the reality of optics. That lawyer is referring business to partner, if lawyer is an associate. Do they feel like, well, I want to make partner someday, so of course I'm going to send it over to my partner's company, or it's just kind of that personal relationship. Like I know that they do a good job. Is that really the lawyer's independent judgment to say, I know this person, I work with this person, I trust this person, and that can be a very valuable thing. Or is there some other just kind of, hey, I'm going to kick some business over to you. You do your closing, you can kick it over my title. You can see, I don't want to portray lawyers in this horribly negative, sort of jaded perspective of just nothing but quid pro quos that are unspoken. That said, I think that's the question of, can something be waived when you have that financial interest that is so close? It's within the firm walls.
Yeah, I think that's the approach or the justification of why you can do it or why you can do it dictates the answer.
Yes.
If you approach it from this point of view, the answer has to be this. If you approach it from this, it could be waived. I think we opined on this, I think, in the the spousal situation, did we several years ago, where your spouse owned the title agency and that, as I recall, that's sort of where it came down in that situation, as well as the approach we took to the I guess the source of conflict dictated whether it could or couldn't.
That's right, and that's what we need to figure that out.
Somebody needs to say something.
I think you're right. Okay.
Okay, one of the things that I've noticed, but I've noticed myself reading the comments and about the title companies, their comments, when we don't do this. I took from that means that there aren't a lot of lawyers that do have this interest in these companies, and if they do, they don't have the greater influence on them that, you know, assumably they would have. So that's a good thing, that they're standing firm, and they believe they're doing the right thing, right, the motion, or, but do I have a motion to keep this over, return to the subcommittee? So, a motion is a second, proper second. Any discussion on that motion? All those in favor, please say aye.
Aye.
Any opposed, nay? All right, and passes over, turn to subcommittee. Next, we're moving to the reconsideration of public opinion. Proposed for 2025. Good. Brian, can we allow to come in? All right, proposed 2025 FBO 3 client consent to annual rate increase. Move on, we got one.
So let's see, 2025 FDO 3. This was published over the past quarter. This is the opinion that deals with the question of whether or not a lawyer can put in their fee agreement, a kind of prospective anticipated fee increase, that can be acted upon, and whether or not the client is supposed to receive notice prior to any fee being increased during the course of the representation. And so we've the answer for these opinions, or excuse me, for these questions, ultimately is that, you know, can a lawyer put that in there? Yes, the lawyer can put some language in the fee agreement. However, the lawyer does need to provide some amount of notice. There needs to be some sort of reasonable notice to say, hey, the fees are increasing because we have it, again, a little nuanced in North Carolina's rule. We have some language in our rules of professional conduct a little different than the model rules in some other states. Particularly the comments to Rule 1.5 basically say that a lawyer cannot threaten to withdraw from representation in a way to coerce an additional fee or a higher fee. And it's the notion that, you know, once you make that fee agreement, once you come to some sort of agreement with your client, then that is the agreement between the lawyer and the client. And any increase, you can propose it to the client, but you cannot, I guess you cannot impose it on the client unless the client consents to. And so there's, you know, of course, there's, I think practice has produced a different sort of reality, that there are a number of clients out there, and this is where we've heard a lot of comments from. You know, this came up in a grievance context, or originated from a grievance dealing with, I believe, a domestic case, you know, and a client that was upset with an increase that got imposed without any sort of notice. And, you know, the client recognized that there was a clause in the contract that said we review our fees on an annual basis. And we will let you know if they increase. And they received the bill, the fees had increased over the past month's work. They were upset with that, felt like they should have gotten some sort of notice, didn't think it was fair. Of course, the client then is put in the position of, I have to pay this. I'm gonna, like, what else could they potentially, or what else could the increase be next year? How long is it gonna take? Things like that. But then I think in that context, it's, you know, that's where the opinion came from. But we received a lot of comments, particularly from larger firms that have large clients, and maybe they have multiple attorneys that are working for a particular very large corporation, and that work continues for years. You know, there may have been fee agreements. I know one of the comments was saying we have some fee agreements with clients that date back 10 years. And we still are operating under those. And of course, over 10 years, the different attorneys that work on this, their fees will go up, and we let our person know, we just increase the fee. Per the contract, and say that we will increase our rates. If they don't like it, then they can always choose other counsel, but we just impose the fee increase, and the client has never really said a thing. And so, you know, it presents this reality of different practices. And the expectations of the clients and things of that nature. And so there's some really good feedback that we received from a number of firms that have that type of practice that I think are worthy of consideration for this opinion. So that we can make sure that if this opinion still draws the same conclusions, that it appropriately accounts for the different types of practices that have been brought to our attention through the comments. And if the opinion needs to change or be tweaked in any way, that we have the opportunity to do that. So it'd be staff's recommendation that this go back to subcommittee to further consider the comments received from the prior board.
Any comments from the subcommittee member, or anyone? Yes.
I told Brian a number of general counsel of larger firms had reached out to me, and I told you that they're willing to kind of huddle with you and kind of talk about issues, not in a adversarial way, but just, hey, here's some of the realities. I would suggest that maybe that would be a good thing to do.
Yeah, I've heard from folks, this is the thing that, we deal with here and not necessarily what the folks in grievance deal with. I heard from a number of lawyers that were saying, hey, if this thing is getting adopted, what exactly, we need to get all of our stuff, we need to be agreements, we need to adjust our language. We want to be proactive about this and make sure that we're complying with the rule. I was just like, oh, that's so lovely. That's wonderful that you guys are being so proactive to be as ethical as possible, even though I know you don't like this opinion. And we deal with that nice perspective here as opposed to the miscreants over, in the groups today. But nevertheless, I fully anticipate meeting with some folks, talking with them, getting input, and having this broad discussion with subcommittee. We've seen this before. We write opinions for the entire state, the entire profession, and that the scope of practice in North Carolina is vast. And how law is done, even in the same practice area from Mercury to Manio, are going to be different. So I think it's great to get this feedback. I thank everybody for providing that feedback, and that's the whole point of publication, is to make the process better. So I hope that we can make an even better product.
Any other comments or any questions? All right, I have a vote. A motion, sorry. Motion to return this to subcommittee. Simple. Motion by a second.
Second.
A motion and a proper second to return it to subcommittee. Any discussion? All those in favor, please say aye. Aye. Any opposed, nay? Well, now move on to our new inquiries. Inquiry of grievance, non-disparagement clause in fee agreement, or as a conditional fee dispute resolution. Nicole, we have this one.
Yes, I do. This is another one that we're gonna see go round and round for a while. This year is subcommittee, definitely. But this opinion, we got from the grievance, committee asking for an opinion on lawyers including a non-disparagement clause as a condition of settling a fee dispute, or including a non-disparagement clause in a fee agreement as a condition of representation. So, the proposed opinion says, no, you can't do this unless. Inquiry number one, the client alleges that the lawyer didn't provide competent and diligent representation. They want their money back, so they filed a fee dispute petition with the state bar. The lawyer is participating in the fee dispute. Of course, the lawyer did not say they provided bad representation and doesn't feel like they owe a refund, but they are willing to give a partial refund on condition that the client signed an agreement to release the lawyer of all claims related to the representation. So the opinion says that no, that kind of language is not permitted, unless you follow Rule 1.H2, which provides that if you're going to negotiate malpractice claims or any claims against a lawyer, then you first have to give written notice to the client and give them the opportunity to seek independent counsel with regard to that settlement cost. And then you have to, once you give that written notice, then you have to give them a reasonable period of time to seek independent counsel if the client so chooses. So it doesn't require that the lawyer must be represented, but it does, the rule requires that you have to give the client the opportunity to go talk to another lawyer, excuse me, before they sign that agreement. So it cites Rule 1.8H and then also cites RPC 84, remember that's the opinion, that says that you can't negotiate away the filing of agreements. So the opinion also discusses the client's ability to seek relief from the state bar if they believe that the lawyer has engaged in misconduct, violate the rules of professional conduct. So the opinion would not allow any language that would allow the lawyer to negotiate away the client's ability to file agreements. Inquiry number 2 is based on the same set of facts, except now we're talking about restrictions on posting negative online reviews. And the opinion says that no, you can't have this broad non-disparagement clause. It cites Rule 8.4D on conduct prejudicial to the administration of justice, and the idea is that clients should be able to post their experience about a lawyer. Lawyers could not infringe on that ability to file or to provide truthful public commentary, and then also again to file agreements or dispute with the state bar. It cites some older ethics opinion, 2018 formal ethics opinion 7, that says that lawyers can't give a quid pro quo for positive reviews, so you can't pay for reviews. And then 2020 formal ethics opinion 1 says that you can't pay a client to remove a negative review. So the opinion goes on to say that such language would be okay if it is narrowly tailored, does not prevent the filing of agreements or a fee dispute. It doesn't prevent speaking truthfully about a client's experience with a lawyer. It can't be coercive as a condition of settling a fee dispute, and it can limit access to the fee dispute program. Inquiry number 3 is about including a non-disparagement language in the fee agreement as a condition of representation. The proposed opinion says that such language is prohibited. It cites the Consumer Review Fairness Act of 2016, which prohibits non-disparagement clauses in form contracts that would prohibit someone's ability to post honest reviews. And so the language in the fee agreement is that it is also confidential, that the client cannot ever talk about the fee agreement to anybody. And I did not want to get into confidentiality. I was just really strict focusing on the non-disparagement clause, but we have heard from Warren Savage, who's on the committee, about his concern about confidentiality and lawyers' ability to include confidentiality clauses in agreements, and he didn't want to load away on that ability. So that's something that the committee is going to need to consider and talk about. Inquiry number 4 is about, can the lawyer condition his representation on clients by executing the written fee agreement that includes a non-disparagement clause? Says no, and refers back to inquiry number 3, which is about the Consumer Review Fairness Act. And then number 5 is, may the lawyer enforce the agreement, and again, no, and refers back to opinion number 3.
A lot. Thank you for that presentation. So of course, we know that staff recommends first to send this to a subcommittee for further study, and you all see on the agenda, their names there, and we have proposed a person to serve on that subcommittee. I first hear from any of you with the reactions to the inquiry if you have any. So first names, Lisa.
Say Nancy and Kevin, I believe, are able to attend, so but Bill's here.
All right, Renee.
What do I think about her? given the fact that we cannot generally respond online, they have what we're talking about here, which I agree with. That's what you're. Also not very nice. And I'm fine with, I'm sorry. I don't have a problem with, on the front end, not allowing contractually, that makes sense to me. You're almost anticipating a problem. But we do regularly get people who just don't like the result, they want their money back, and they go online and they, my experience, we either get 5-star reviews or 1-star reviews, or the 1-star review, I wish I could give a -5. And there are times where you don't mind giving the money back, but at the same time, they continue to just go on and on and on. Some of these people are in the system. Another firm, for example, that in full disclosure, I taught CLE ethics on this issue, and Google's a good example where they just go in and they change one word in the review, and it shows up as your newest and #1 review over and over and over again because they want to inflict pain. If it's a part of a fee dispute and you don't limit, you still go to bar by agreements, I'm not limiting that. And I'm not contracting the front end. I'm okay with negotiating now with them and saying, you know, non-disparagement. And I don't have a problem with that procedure, and I think that's consistent with old professional conduct. In the very rural world that I'm in litigation, it's extraordinarily common for clients to review or look at reviews. I regularly get people saying they see our reviews. And I want to maybe have more of a rifle approach as opposed to a shotgun approach, a little bit more here, whereas there should be certain limitations that would allow it as part of the negotiation process, in my humble opinion. But I see the other side of things, so that's just kind of how my big picture perspective is. I don't know how the bigger firms deal with it. Smaller firms, it's something that we live in. I do criminal defense. We do a little bit of family law, and I do plaintiff's work, which everyone knows. No one ever complains about the results of any of those 3 practices. So, you know, we could prevent people from buying or selling or getting good reviews or incentivizing it, and I agree with that. I mean, there's a line of distinction we can clearly draw where you say not those disparaging materials not return your leave, and then you can put in, sometimes you put language in that if asked about this, the matter has been solved or remedied from an acceptable fashion between parties or something like that, if we're asked about that. But if they want to file agreements, that's their right. So, sorry, it's a little bit of a meandering thing, but I like certain aspects and other aspects I'm a little concerned about as a day-to-day health practitioner.
Thank you, sir. Sound like you've been your spot. Any comments for anyone?
I have one sort of random comment, because he is very much an internet out there person, and so I follow him and learn from him. But I will say, you know, to Nancy's point earlier, the whole purpose of this committee and everything we do is to protect the public. Ancillary to that is protecting good lawyers doing good work so they can continue to serve the public. And the people like Bill who do the work, the 3 practice areas that most lawyers do not want to do for this very reason, then we have to have a vehicle for trying to write the record or something, because at the end of the day, while it does protect the lawyers doing good work, that in turn protects the public. So this is just not about, and when we hear the word disparagement, we always think, because of that word, that there was smoke where there was fire, or there's something to it. A lot of this stuff is absolutely false, and not allowing lawyers to defend themselves in the public domain against completely false information is just a situation that we need to be aware of and try to remedy it.
Anyone else? All right, do I have a motion to send this to subcommittee? Thank you, sir.
Second.
And thank you for that. Second, I have a motion and proper second to send this to subcommittee. Any discussion on why this that we're getting? All those in favor of the motion to send this to subcommittee, please say aye. Any opposed, say nay. All right, we'll go to stuff. All right, we don't have any ethics advisors.
Nope.
All right, so we'll move for approval for transmission to council, proposed 2025 FAO, negotiating licensure reporting capability for mediation. Well, this one quite a bit.
Bill, you wanna take this, you want me to do something?
Go ahead, Brian.
Okay. 2025 FQ2 was published over the past quarter, no negative comment, no comment at all, we received. This of course deals with the situation of the professional responsibility of a mediator who is asked to participate in some sort of resolution that includes a clause that basically the lawyers would not tell on each other should anybody commit any type of rule violation. So typically, we will, the committee has approved these or vote to send these to the council for adoption after publishing with no comment. That said, David Allen really loved this subcommittee and talking about this issue over and over. So
Thank you.
we're happy to send it back to subcommittee. Just okay.
You sure? Huh?
Pretty darn sure.
Yeah. But yes, that's historically with no comment, then the committee typically sends it to the council for adoption.
Do you have any further comment?
I would so move that we submit this to the council for adoption. Is that the proper motion?
Yes.
Certainly.
Do I have
seems
a
proper.
second to that motion? Second. Any discussion? All right, all those in favor of sending this to council for adoption, please say aye. Aye. Any opposed, nay? All right, we'll send that to council for adoption. And we have gotten completely through our agenda. We have one little piece of the information.
I think most everybody knows, but this is gonna be my last meeting, after hiring, October 15th. So that's before the meeting. This has been great, meeting to be part of. I've really enjoyed, all the discussions and the debate that go on and, really learned a lot from everybody, and just working at the bar has been just the best job of my life. I've worked with some of the best coworkers and Nicole. She loves me. Really gonna miss everybody, and just thank you for all that y'all have done and helped me with. So shout out to you. So right now there's 4 people watching, so in October there'll be 5.
So Suzanne, I want to tell you that, I have been extremely honored to serve with you. You, of course, did on this, been a part of the staff for the entire time that I have served. I have learned so much from you. And I know you said that you have a great staff that you work with, but I consider you and Nicole especially as a dynamic duo. And I appreciate having learned from you and poured into me in every way that you have. And just even the time when, we went to that conference once, and I got to know you a little bit more, on that personal level, and I appreciated that. And I wish you well. I am super sad. You will be off, but kind of personally, I mean, it's usually going out at the same time I'll be going out, so. But at the same time, I'm sad for the bar, and Jill really are a phenomenal person. And you have done great work on this committee and this agriculture staff member in general, so I appreciate your work.
I do feel like application, sure.
Yeah. Y'all be okay. So I don't know if anybody else wants to say anything. We're done with our agenda for even a short time, but I don't want to just put it up, put out there, put it on the spot, but I do want to allow us to make comments if you would like to. Sure you get down to the hook.
I would start talking, but I know Suzanne will probably kick me off my scooter if I. I'll talk.
Thank you. Everybody. Thank you.
Yeah.
That's okay.
The farm.
Yes, sir.
Thank you for having me.